The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about some common mistakes that trustees make when administering a trust and how you can avoid them. So first, let's talk about what a trustee is. A trustee is the person responsible for managing and distributing the assets of a trust for the benefit of the beneficiaries of the trust according to the trust terms. So the trustee has to follow the terms of the trust, and when the terms aren't clear on what the trustee should do, the trustee, when acting in their discretion, has to act for the benefit of all of the beneficiaries and not pick sides between the beneficiaries or self-deal. So those are the basic responsibilities. Most of the mistakes we're going to talk about have nothing to do with intentional wrongdoing. They are just things that a lot of trustees don't think about and do wrong on accident. So let's talk about what those might be. So one is if there is an ongoing real estate transaction involved, you may be able to terminate that transaction, and it may be in the best interest of the beneficiaries to do so. So if the deceased person was in the process of selling their home, it may not be tax beneficial to continue to sell the home for the trust. One of the beneficiaries may want the home transferred to them directly, and the beneficiaries might agree to that. So don't automatically assume that you have to go through with the real estate transaction. Another mistake is liquidating retirement accounts. Now, sometimes this makes sense, but again, the beneficiaries may be able to roll these retirement accounts into their own retirement accounts, IRAs and 401ks, without having to pay taxes on them. So if there's retirement accounts involved, you always want to be really careful. You don't necessarily just want to cash them out because there's a tax implication if you do that, and it may be more beneficial to roll these accounts into beneficiaries' accounts. Missing court deadlines is a big problem. So if you're administering a trust, you may also be involved in the administration of a probate estate as well that goes along with that. And in that case, you're going to want to know what the deadlines are for. There's notices you have to file, reports you have to file to creditors and beneficiaries. So talk to a good estate attorney to make sure that you at least, even if you're going to manage everything on your own, at least have a schedule of the upcoming deadlines and know what you have to do and know when you have to do it by. Failing to file the trust taxes. So if you are managing a trust over the course of multiple years, say there are minors involved and you're managing the assets for the benefit of the minors until they reach the age of majority, every year you're going to have to file an income tax return for the trust. You're also going to have to, if you're dealing with someone's estate, file an income tax return for the deceased person and estate income tax return, so income that the estate generates, and potentially even estate taxes, which are taxes on the state and federal level on estates that are over a certain threshold in value. It's also important that you keep detailed records of every transaction. So you have an obligation to report to the beneficiaries if they want to see them, all the transactions in and out of the trust, and often you should keep track of your rationale for certain distributions to beneficiaries or why you denied them if that was within your power. But everything you do that affects the trust, you want to keep a good detailed record, and this will protect you from liability later on and make the beneficiaries feel better about the situation and have peace of mind knowing that they can get these records from you. Paying out of the wrong pocket. So one, you never want to commingle trust assets with your own assets. That's kind of elementary. Everybody kind of knows that. What's a little bit more complicated is that certain beneficiaries, according to the terms of the trust, may have rights to income or interest as opposed to principal. So principal is the amount that was put into the trust in the first place. Income or interest is generated on that principal. And a lot of trusts specify that every year a certain beneficiary is going to be paid from the income of the trust, but the principal is going to remain intact so that it can continue to generate income or interest. So it's important that when you make a distribution from the trust, you know whether it's supposed to be a principal or interest or income distribution, and you don't pay from the wrong pocket. Misunderstanding a trust's terms and provisions is another big one. So these trusts can be arcane and complex, and ignorance of the trustee is no excuse for doing things wrong. So this is where you want to consult an attorney if you're not sure what your obligations are according to the trust terms as far as managing or distributing the trust. Talk to an attorney, and they can at least, even if the trust is vague in and of itself, If you talk to an attorney, that protects you from liability if you were advised by an attorney to distribute or manage the trust in a certain way. Don't forget about future beneficiaries as well. So there may be beneficiaries that have an interest in possession of a property, and other beneficiaries have the right to inherit that property when the present beneficiary passes away. So you need to make a distinction between current interests in property held by the trust and future interests that have already vested. So that's different from a contingent interest. And I won't go into a lot of the details here, but there may be multiple layers of beneficiaries, some that have current rights and others that have the right to do something in the future, and you need to be aware of what everyone's interests are and make sure that you don't forget about those future beneficiaries. Finally, if you have any questions or if you're worried about making any of these mistakes, you should always consult with an experienced trust administration attorney. It doesn't have to be expensive. One of the reasons that people set up trusts, especially revocable living trusts, is to make it so that you don't have to pay a lot of attorney's fees in administering the estate. But even so, it helps to talk to an attorney to at least help basically be your consultant and help you understand the rules of the game, even if you're doing most of the legwork and you're not paying them much in fees. So if you have any questions, you can leave them in the comment section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and you'll be notified of our daily article and video topics. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.